Simmons. I'm your Washington Realtors Legal Hotline lawyer, and today we're once again reaching into the mailbag to bring you today's question and answer. And here's the question. Buyer has made an offer with a very large non-refundable earnest money. The earnest money is in excess of 5% of the purchase price. If buyer fails to close the transaction, will seller be allowed to keep that entire earnest money? And the answer is, if nothing else happens and the buyer has simply presented this offer on the statewide forms, purchase and sale agreements, and seller accepts the offer as is, the answer is no. Seller will not be allowed to keep more than 5% of the purchase price. Now, sometimes brokers will say, well, what if we call it earnest money, or what if we call it something else? It doesn't matter, okay? The court will look at the totality of the money that the buyer is forfeiting, because that's what's happening. Buyer is forfeiting money to seller as a penalty for failing to close a transaction. All right, I've used some buzzwords here, and you need to understand this question in the judicially historic context in which it is actually presented. Here's how this issue came to be. First, Washington law prohibits penalties. Washington law prohibits a contract to say that if a party fails to take some action, they will be penalized as a result of failing to take that action. Set that word penalty aside for a minute, because what Washington law does allow is for the party who did not breach to be compensated for their losses. So here's the distinction. Compensation for actual losses suffered because your contracting party breached, that's allowable. But a penalty is unenforceable. Okay? Keep that in the back of your mind. Now let's talk about some history. There was a time when the legislature allowed what we call liquidated damages in a real estate purchase and sale agreement, and said that a liquidated damages provision under certain circumstances would be enforceable. A liquidated damages provision is what we just described as money going to the seller if buyer breaches. So we could have a liquidated damages provision, we refer to that as an earnest money provision, in a purchase and sale agreement that would say if buyer breaches, seller can claim the forfeiture of the earnest money as liquidated damages to make the seller whole, notwithstanding buyer's breach. A court decision came along that impacted that legislative provision. And then the question became, what if the amount that buyer is required to forfeit is too great? So through a series of back and forth between the legislature and the courts, both have now reached the same conclusion. So in common law, through court decisions, and in statutory law, we have the same exact outcome. If a buyer in a real estate purchase and sale agreement is required to forfeit no more than 5% of the purchase price, that's deemed by both the courts and the legislature to be reasonable. It is a reasonable forfeiture, and it is not deemed to be a penalty. Anything more than 5% may be a penalty and may be unlawful. The reason I say maybe is because once you go beyond 5%, the answer to the question is dependent upon the language included in the purchase and sale agreement itself. So remember in the beginning of this question, I said if the parties do nothing more and buyer simply presented this offer on statewide forms and seller accepts it, then certainly seller could recover no more than 5% of the purchase price. That's because the statewide forms are established based on Washington law from both courts and the legislature setting a 5% limit. If for some reason it's important for a seller to have more than 5% of the purchase price as their liquidated damages in the event buyer breaches, then seller is going to have a specially drafted provision. And it sometimes is important for sellers to have a liquidated damages fund of more than 5%. Maybe buyer wants to have an extraordinarily long closing period. Maybe buyer wants seller to make some extraordinary modifications to the property prior to closing. And in any event, seller is going to be damaged if this particular buyer fails to close this particular transaction. If your seller is in that position, then you've got to get that seller to legal counsel. Seller's lawyer must draft the provision. And the provision will have to contemplate the fact that seller has anticipated what their actual damages will be if this buyer breaches, and that buyer and seller have agreed that the amount of money that will be forfeited is a representation of seller's expected actual losses. This provision is not going to be easy to write. This provision is not something that any real estate broker is licensed to draft. Seller's lawyer, and honestly, if seller's lawyer isn't up to speed on these issues in particular, seller's lawyer is probably going to have to read some case law before seller's lawyer can draft this extraordinary earnest money provision. So, real estate brokers, please do not draft this provision. Because if the provision fails, and it turns out that the seller believed that they could retain $100,000 earnest money, but in reality they can only retain $30,000 earnest money, who are they going to come to for the difference of $70,000? The buyer is already in the clear. They won the lawsuit that said seller can retain no more than 5%. So seller is going to look to the real estate broker who drafted that provision, if a real estate broker drafted that provision. Your E&O insurance is probably not going to cover this, because when you draft provisions that are outside the parameters of filling in the blanks in your standardized pre-printed forms, then you're engaged in the unauthorized practice of law. So this is an issue we're seeing more and more in today's seller marketplace. If your seller is demanding an extraordinary earnest money provision, you've got to send that seller to legal counsel. Do not take the temptation of drafting that provision for your seller. And frankly, in today's marketplace where we're seeing prices escalate so rapidly, it's entirely possible that seller will be told by their own legal counsel that there is no way to justify this provision, because in a rapidly increasing marketplace, sellers' actual losses may not be able to be reasonably estimated at something more than 5%. Of course, that decision will have to be made on a case-by-case basis, which again is why you need to send your seller to legal counsel. If you have questions on this topic or any other, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.